Our next speaker is Graham Smith, who's a partner at Bird, and he's going to speak about communications data. Thank you.
Thank you, Ian. I'm not sure this talk fits specifically into this panel, but it is certainly a good follow-on from what you've heard already about interception, about acquisition of communications data, and I'm going to complete that story by talking about mandatory retention of communications data by intermediaries. As you can see, as in the Senate partner at Bird, I tweet under @cyberlegal. I know some of you here follow me, which I'm very grateful. Please feel free to do so. Or quick plug, I have my blog under cyberlegal, cyberlegal.com. So the first thing's out of the way. The context for this is now the forthcoming Investigatory Powers Bill, which you've heard something about already. It is a rewrite of DRIPA, the existing interception and communications data acquisition regime, of DRIPA, the existing data retention regime, of the Counterterrorism and Security Act 2015, which added to the data retention regime, and also of various powers given to law enforcement under and intelligence agencies under things like the legislation that governs the security agencies, such as the Intelligence Services Act. It's the product, as you've heard, of 3 separate reviews which have nearly 200 recommendations between them. We expect the draft bill to be released for pre-legislative security. I think the betting is sometime in mid-October, although no date has been published, I don't think. It's going to cover interception, bulk interception, targeted interception, and the new kid on the block, thematic interception. It's going to cover interception, and the interception rules cover both content and related communications data that are scooped up as part of that. As you've heard, it will also cover what they call in-equipment interference, which is state-authorized hacking powers for the agencies. It will, as I say, cover communications data acquisition and disclosure and mandatory communications data retention. It may also cover encryption and possibly some sort of obligations on monitoring by intermediaries, although that seems to have been presented more in the sense of ethical and moral obligations rather than legal obligations, but we shall see. As I say, this is coming up within the next month or so. One of the issues around mandatory communications data retention is the government's promise, let's put it that way, to bring back at least some of the communications data, the draft communications data bill, which was heavily criticised and blocked by the coalition back in 2012, and which would have increased very greatly the scope and extent of mandatory retention of communications data by intermediaries. This was, much to the annoyance of the supporters of the bill, dubbed the Snoopers Charter, and we have a lot of people saying that this will be brought back as the Snoopers Charter. We have campaigns about it. We have it's closely associated with Home Secretary Theresa May, and you can see here a typical suggestion that the new bill is going to be bringing back this charter. So what I thought I would do is take us back a little bit in time, see how we got to where we are at the moment, and in the light of that, see if we can see what new might be added in the Investigatory Powers Bill if the promise is carried through to bring back at least some of the draft communications data bill. So we start back in 2001 with the Anti-Terrorism, Crime and Security Act. This was in the aftermath of 9/11, and it made provision for a voluntary retention code of practice, which was designed to put in place a framework which would enable intermediaries to communication service providers to retain various categories of communications data on a voluntary basis, but without breaching data protection, privacy legislation. And it specified various different periods for different types of data, 12 months for subscriber information and telephony data, 6 months for data around various types of, I can call them human-originated communications, SMS, MMS, emails, and so on, and also things like log-on and log-off information about internet access. Significantly, when we come to look to what may be coming up now, it also provided for retention of what is now called web-logged data. 4 days worth here of web activity. In other words, URLs, but defined only up to the first slash, the sort of domain name bit of the URL, what services were being accessed, and so on. A lot of data, which is presumably why they only provided for 4 days worth. That was and is voluntary. The code is still extant. Then after the Madrid bombings and 7/7, we had the EU Data Retention Directive, 2006, and that was implemented in the UK for Internet in 2009 by the 2009 regulations. And this overlapped to a large degree with the voluntary code, but did not include, but was more limited, and certainly didn't include web activity data. So you can see that it relates to things like fixed and mobile telephony, internet access, email, internet telephony. Quite a limited range of types of communication and activity, and had some limited amount of sort of location type data related to those types of communications. Then a large spanner appears in the works, inserted by Digital Rights Ireland and the European and the Court of Justice, the Digital Rights Ireland case, which invalidated the Data Retention Directive in its entirety. A whole lot went. And that left the 2009 regulations dangling without too much visible support. And 3 months later, in July 2014, the government pushed through in 4 days, notoriously, the Data Retention and Investigatory Powers Act 2014, known as DRIPA, and that essentially reenacted the categories of data types, retention, which were in the 2009 regulations, although with a bit more flexibility. Rather than specifying 12 months, it allowed the Secretary of State to specify periods up to 12 months for different types of data. But in terms of data types, it was exactly the same list as in the Data Retention Directive. The government also took the opportunity to expand, or as the Home Office would have it, clarify the definition of communication services providers so as to include, or clearly include, webmail and indeed pretty clear social media platforms of all sorts. So that was DRIPA. That was immediately subject to a legal challenge. Oh, sorry, I should have said yes. DRIPA, part of the deal was that DRIPA would be subject to a sunset clause. It would automatically terminate as at 31st of December 2016. We then have the Counter-Terrorism and Security Act, which added something called IP address resolution data. I've been given 1 minute, so I can't tell you what that is, but it is difficult, and it's a poorly drafted piece of legislation. So But anyway, that added to the types of communications data that could be required to be retained. DRIPA was subjected to a judicial review, claiming that it was non-compliant with the EU Charter of Fundamental Rights, and in July 2015, the High Court agreed and disapplied Section 1 of DRIPA and indeed the CTSA extension of that, insofar as it didn't satisfy certain requirements laid down by the ECJ in Digital Rights Ireland. It suspended the effect of that disapplication until March 2016, so we now have another deadline, as well as the sunset of December 2016. We have March 2016, by which time government has to work out if it can, a compliance way of effectively reenacting DRIPA. So all that, as well as all the interception and everything else stuff, is going to be folded into the Investigatory Powers Bill. And then, back in 2012, as I say, we had the Draft Communications Data Bill. And if we jump forward and say, well, what of that might come into the Investigatory Powers Bill, the sort of things that one might look out for are going back to the 4 days at the top, that type of weblog data, browsing history, Home Office say only up to the first slash, but still quite revealing. What I call digital footprints, the sort of data that this thing gathers as you go about the place, and location data, and it's not just about sending emails and text messages, it's every time some app on here checks back at home, updates data, updates the newsfeed, location data potentially associated with that. So you end up with potentially a minute by minute or hour by hour, if you like, record of what you've been doing and where you've been going. So an immensely richer variety of communications data, possibly expanding to relate to sort of over-the-top type services. It had an extraterritorial aspect as well. And one thing I particularly focus on, which I don't think a lot of focus in the reviews, is the data generation. The existing data retention powers apply only to data which communication service providers generate or process within the UK in the course of providing the service. So if it's not data that they actually generate or process in the first place, they can't be made to retain it. The Communications Data Bill said we can require service providers also to generate specific data for these purposes, which to my mind is a very, very significant extension of the powers. So I will, I've run out of time. There are other things to say about it, but maybe any questions. Thank you.
Thank you.